So welcome everyone to today's webinar. And before we begin, I just want to make some housekeeping points. First of all, I want to indicate that this webinar is being recorded and is also being live streamed on YouTube. Another, I want to request all the participants to keep their mics on mute and videos on off to avoid any disturbances. And if you would like to raise any questions for a panelist, you can put it in the chat box in Zoom and direct it to the co-hosts of the webinar, and we will take them up in the question and answer session after the discussion. And as Udai has already highlighted that we currently already have 64 participants and there are 170 registered participants. And the session is also streamed on YouTube. So over to Udai now for opening remarks. Thank you.
Thank you, Shubhangi. Good afternoon to all the speakers and the participants. Thank you for taking out your esteemed time to join us for today's very timely webinar. The much-awaited report on the non-personal data governance framework was released recently, as all of us are aware. The report aims to unlock the immense potential of non-personal data in creating social, public, and economic value for citizens and communities in India. To this end, it also intends to create certainty and incentives for innovation, foster an enabling data sharing framework, and encourage startups. While an extremely timely initiative, we must say, the assumptions, findings, and recommendations of the report needs to be analyzed dispassionately, and the impacts on different stakeholders and regulatory landscape requires a much deeper examination. Few of the issues, just to highlight, include the regulatory overlap between the Personal Data Protection Bill 2019, competition law, draft e-commerce policy, and the consumer protection laws in India. Apart from this, to realize the potential of data in the economy and to also check abuse of dominance in the data markets, it proposes for mandating data sharing mechanisms. However, it remains to be seen what impact this will have on intellectual property regime, innovation, and competition in the digital economy space. As Cuts, we eagerly look forward to hearing views of the esteemed panel on some of these issues during the panel discussion. Last but not the least, the rights of the community and individual data principles and grievance redress mechanisms needs to be solidified. Given that many ideas in the report are in the formative stages, these needs to be thoroughly discussed for enabling the design of an optimal governance framework for non-personal data in India. The framework should take into account principles of transparency, data protection, stimulating free and fair competition, supporting innovation and research. Given this, the Cuts webinar brings speakers from judiciary, parliament, subject experts comprising from legal and competition field to shed light on these issues and suggest a way forward. The discussion of this webinar will be synthesized in form of our draft comments, which we shall be submitting to the committee, and also for further dialogue and advocacy. Furthermore, I am also pleased to share with all the speakers and the participants that as Cuts, we will be launching very soon a research project to review data sharing mechanisms in different jurisdictions and suggest a way forward for India, considering a relevant stakeholders' perspective. With this, we look forward to a very engaging and a fruitful discussion. And I request my senior colleague, Mr. Bipul Chatterjee, to take forward the proceedings of the webinar. Thank you very much.
Thank you, Udai. Let me join him on behalf of Cuts International to welcome all of you. Good afternoon, everybody. So, it is evident from what is appearing in the public domain over the last few days, and given the fact that there has been so much of discussion on this subject, there is absolutely no doubt that it is very, very important for all of us. Why it is important? There's some. I think the question is not whether we regulate non-personal data or not. The question should be what is to be regulated and how, and who is going to regulate that. I have a couple of points to make before we go to presentation, a very brief presentation by one of our colleagues, Kapil Gupta, followed by a panel discussion. We have an excellent panel today, and I think we have enough time, not just to brainstorm, but also to come out with a forward-looking agenda to take this subject forward for the interest of the people of India and the Indian economy. Now, by non-personal data, I mean we have been using this various services, various platforms for our different usage. It could be ride sharing, it could be ordering some food, it could be ordering groceries, and you mean it. You say, and our life is becoming so much digitized these days. A huge amount of non-personal data is being generated every second, not just minute. Therefore, it is important for us to understand and how is it going to be used. But before that, a question which arises to my mind: who owns this data? Is it the companies, Olas and Ubers of this world, or is it the public? I mean, people like us, consumers, through whom this data is being generated. So unless I take part in this market, this data is not going to be generated. So ultimately, it is the people of India who owns this data. That is my personal opinion. We may differ. We'll come to know how we should treat it. And then that brings me to the second question, which is about uh, how to regulate it and what to regulate. And most importantly, who should be the regulator? I don't think that we need a standalone regulator for this purpose. Another parking place has to say. But I think there are a number of bodies in this country, and given the nature of this data, it straddles so many sectors. I think, and this is subject to our debate today, even today, I think the Competition Commission of India is best suited for the purpose of its regulation. Now the question is, how are they going to access it? What kind of rules, rules and regulations are going to be applied? Are you going to see different types of regulations for Indian companies or foreign companies? Are going to apply most favored nation and national treatment clauses or principles? So these are some of the questions which are coming to my mind, and we need to find, I think we need to find answers to these questions in order to take this agenda forward. I'm sure there are many other questions. We have experts to discuss them. So with these brief remarks, once again, let me thank my colleagues for taking this issue up. Very important from consumer perspective, from the point of view of consumer welfare as well. And therefore, let me now request my colleague Kapil Gupta to make his presentation. Kapil, over to you in about 8 to 10 minutes. Thank you.
Good afternoon, everyone. So I'm going to present GUT's preliminary response on the report by the Committee of Experts on Non-Personal Data Governance Framework. Since today's webinar focuses on issues of regulatory harmonization, data sharing, and consumer empowerment, my presentation would briefly touch upon these issues. However, GUTS plans to make detailed submissions on the report, and today's discussion will add a lot of value in further articulating the concerns in the report. Now coming straight to the issues at hand. The first one, regulatory harmonization. The report lays out importance of the digital economy and a need to regulate both personal and non-personal data. However, the report does not clarify how existing regulatory framework is lacking to solve issues. The scope of NPD is unclear. Why is there a need for separate regulator for NPD? Can the Data Protection Authority under the PDP bill would be more suited to address issues surrounding both personal data and non-personal data? What makes Data Protection Authority ineffective that warrants a separate regulator? Similarly, there are definitional overlaps between personal data and non-personal data when it's about mixed data sets or inferred data. E-commerce is a prime example where data may contain personal information as well as shopping history and sales data. The report has illustrated that in the EU context, if there is an overlap, GDPR regulation would prevail. However, the report does not talk about the Indian context. There are also jurisdictional overlaps with different sectoral regulators, such as the proposed e-commerce regulator, the Reserve Bank of India, the Competition Commission of India, Consumer Protection, etc. The outlook in the report that has been given is too broad. There is a need to narrow down on the specifics in the report, and it should aim to create regulatory harmonization. To this end, when there are glaring overlaps between regulators' jurisdiction, a memorandum of association can go a long way to address any discrepancy in dealing with the issues. And most importantly, a regulatory impact assessment by the NPDA is a must. Do we need two regulators, or a single regulator would be more effective in regulating the issues of personal data and non-personal data? Or would it make Data Protection Authority a super regulator? Now coming to data sharing. There are a lot of, next slide please. There are a lot of unaddressed issues here. While the report focuses on data sharing to address issues of competitiveness in the market, however, it does not talk about network effect and platform neutrality. Here it falls short. Competition Commission of India, however, is a statutory body to address such competition issues in a holistic manner. And accordingly, CCI needs to be further empowered to address competition issues of digital economy. On similar point, the report does not present effective evidence as to how all data create barriers while without taking into account network effect and platform neutrality. The report also mandates data sharing with the government for sovereign purpose, but fails to provide clarity on the applicability of the three principles that was laid out by the Puttaswamy judgment of legality, need, and proportionality. Similarly, the report does not present evidence as to why a certain approach is most effective. In this regard, why mandatory data sharing by private companies is a better policy than self-regulation or incentive-driven voluntary sharing? Or is it better to leave data sharing to the market forces and contracts to decide? What incentives are more effective for companies to voluntarily share data? Similarly, while companies may be investing substantial resources to collect raw and factual data, however, why such data collection activity should not have a remuneration value? There is also a lack of clarity on adjudging the value that should be appropriated on a value-added data set. When does a raw data becomes a value-added data set? Clarity on this transition is also missing. There are also concerns of intellectual property rights with raw data, factual data, and value-added data sets. How would that work out? There are other challenges relating to investment, innovation, etc. In all, there is a need to clarify the role of non-personal data regulatory authority on competition issues. And there's a further need to strengthen Competition Commission of India's approach in dealing with competition issues of digital economy. While, among other things, data sharing is aimed at helping startups and understanding how will it impact or incentivize the startups is very much necessary. The policy should not cause adverse impact just for mere gains. Now, coming to the last section, consumer empowerment. For personal data, a data principal is a natural person to whom the data relates. For non-personal data, data principals could be individuals, companies, and communities. The framework under which data principals can exercise their right and how lacks clarity and details. While the report acknowledged the importance of consent by individual data principals for anonymization and its usage, however, a user perception survey conducted by CUTS on sensitivity revealed that consumers do not read privacy policies, mostly on account of length, legalese, and language. So, how appropriate and effective consent could be is questionable. Similarly, the sensitivity of information should be adjudged following the deliberations with the consumers. Another issue here is that when the data is inferred, an individual wouldn't know if he or she belongs to a certain classification or categorization of a community. In such a scenario, how would individuals exercise their rights within community about which they often don't know? Most importantly, there is also a challenge of multiplicity and conflicting interest within community, and the report does not clarify on this as well. Similarly, while the report talks about collective harm, it does not illustrate appropriate redressal mechanisms. Shouldn't be the approach to adopt a more risk-based regulation. In all, there is a need to further strengthen focus on consumer welfare and adequate mechanism on transparency and accountability of data principals to exercise their rights. To conclude, next slide, please. Yeah. To conclude, there is a larger need for better clarity on the overall scope of the NPD governance framework. We should avoid putting the cart before the horse. There is a greater need for ex ante cost benefit analysis of the regulation to assess the impact of the regulation and make regulation optimal for all stakeholders, most importantly, startups and MSMEs. Similarly, there is a need to have a larger focus on consumer interest and welfare and mechanisms for accountability and grievance redress. Lastly, regulatory harmonization is fundamental for the successful implementation and to achieve the objective of the policy. Considering the vastness of the digital economy and underlying issues, a whole of government's approach can be a way forward to optimally address effective policy intervention. With this, I would now request my senior colleague, Mr. Chatterjee, to please begin the next session of the webinar. Thank you all for listening and looking forward to hearing the panels. Thank you so much.
Thank you, Kapil. As it is very clear from your presentation, the issues are very complex. And it's not possible for one particular set of people, be it lawyers or economists or technical guys, to understand all these issues in a holistic manner from different angles and then come out with the right type of regulations for the benefit of the people of India and the country, our economy. And that is why it is necessary to have all types of wisdom or expertise and knowledge to address these issues. And this is, I think, it's a subject where we need a whole of government approach, not just to have good policies and regulations, but also to see how one sector is related with another and can benefit, can generate externalities, positive externalities, so that the sum of parts are greater than the whole. So with these brief remarks, may I now request Justice Brian Srikrishna, who is the chair of the Committee of Experts on Data Protection, for your thoughts, sir, on this subject. How can we come out with a forward-looking agenda for the benefit of the Indian economy and its people? Over to you, sir.
See, I carefully read the report, and to my mind, it appears that the remit of the committee appeared to be that this is an asset which can be owned by somebody, therefore find out method of trying to regulate it. Now, the terms, there are no terms of reference in the report that I noticed. The only general vague term is to discuss and consider all issues pertaining to data. Now, the first fundamental issue that you need to consider is data an asset in that sense? Is it something that you can own? I don't like the idea of somebody saying data can be owned by somebody. It's as bad as saying that my children can be owned by somebody or my friends can be owned by somebody. Data is an essential relationship between one matter and the person. For example, my name is not my property. I can't mortgage it to somebody for 6 months and you obtain money on that. That where you want to do it, you must have a separate act like the IPR. Please note, IPR basically you had a similar issue. Therefore, there was a very careful thinking on that whatever is the result of the intellectual pursuit of a human being should be monetized by making it an asset. That is why today your IPR rights are shown in the balance sheet of a company as an asset. Now, would you tomorrow show your data as an asset in the company's balance sheet? I have not understood how you are going to do it. Because first question is it a right or is it an asset? Now, the difficulty that arises is if you confound or confuse the right to own an asset and the asset itself, infinite confusion has come about as a result of that. Now, what are you regulating? Are you regulating the ownership or are you regulating my right itself? Now, the committee has gone about and said, first of all, I am very much against the negative definition. The negative definition causes, again, infinite confusion. One can understand defining personal data is something that is intimately connected with the individual human being. But the moment you say non-personal data, everything in the universe other than a personal data becomes automatically non-personal data. So there is going to be, again, a lot of, what was said earlier in the presentation is absolutely correct. There is going to be a lot of interplay between the two, lot of overlap. And the overlap creates a big confusion and a big difficulty also. The difficulty is this: if it is personal data, it is my fundamental right. If it is non-personal data, it is doubtful if it is a personal fundamental right. Therefore, the legal impact will be different on both the sets of rights. Therefore, there must always be a bright line test which will say beyond this line, it is non-personal data, and before this line, it is personal data. I can understand the committee has not gone into these nuances of law because they were just generally discussing the economic viability of controlling data, regulating data and all that. But even then, there is a lot of difficulty. It is right been pointed out that today, if you are a producer of something and a producer of another is competing with you in the market, you have this concept of competition, market dominance, abuse of market and things like that. Now, I don't see why such an issue cannot be raised before a competition issue, a competition commission, and similar principles applied, except that it will be not in the produce market, not in the service area, but in the area of digital marketing. Now, I'm sure it can be adopted by suitable amendment or perhaps even without an amendment by a little bit of creative thinking. Now there, please look at what happens. Supposing you have a giant company, which whole business of the giant company is data, collecting and processing data. And you have another company which is doing e-commerce. Now, if they both of them join hands, what happens to the rest of the market? This is an issue that needs serious consideration. We saw what happened. I don't want to go into the names of the company. There was serious concern about two companies merging or doing strategic investment. Then again, the issue that arises is the committee has divided non-personal data into three compartments. One is data collected by government and public bodies. Now, where the government collects data in two methods. One is data collected from the citizen for rendering him a service. Now, for example, I go for driving license, I have to give some data. If I go for a bank account, I have to give some data. If I go to a railway station to obtain a ticket, I have to give the data. Now, this is data over which I have dominance. There is no difficulty, that is personal data. Now, once it is collected by the government body or the public body, does it become automatically non-personal data? One of the things I noticed in the committee is they say that the persons, when they give their personal data, should give consent to anonymize it. Should means what? Compulsorily, or is it meant that they should be asked to give that consent? If it is the latter and I refuse to give consent, then how will you anonymize it and then use it without infringing my fundamental right? That is going to be another problem. Then the government may also have data. For example, the government may take out a survey of all the land that is there in the country, or different areas where laboratories are situated, or atomic energy establishments is there, or some other sensitive equipment is maintained. Now that is government generated data of which it has the full right, nobody can question it. But when the government collects data from me, whether it's the municipal corporation or some other public body, that is my data you are collecting, and don't tell me that you will anonymize it and say that I have lost all my rights. That I think is a little difficult to accept. Then the second is community data. Now this community data is somewhat very nebulous and sketchy in its conceptualization. Now what does community mean? Geographical entity, so all the people in Delhi will have a right to it, but people in Mumbai will be denied the right, or all the people in say CP area will have the right to it, or in Lutyens Delhi will have the right to it, but the people in Qutub Minar area will not have a right to it. Does it mean that kind of a distinction? Or then there is some unity or on the basis of work that is done. Like for example, they have said all the taxi, hail cabs or e-commerce entities. Now, so what happens if all the lawyers put their data in a particular, in the cloud? So that is become a community data which every lawyer over the country can access it. Now, these are issues which are left loose. Now, there is, I assume that when the law is really concerned, and ultimately these are recommendations, it is the law which will govern the citizen. And when the law governs the citizen, all laws must be citizen-centric. All laws must be human-centric. Now they should try to protect him and then build a law around it. Now it can't be other way around. You can't say that, oh, this is good. There is a lot of available economic value available. Let's think of regulating it. No, don't just see who has regulated, who is the one that has generated this, give him due credit, and then think of whether it could accept it with or without his consent. Now, the last issue that really bothers me is private data. Private data is what a private company collects. Now, a private company collects a lot of data. You may have employees data, you may have customer database, you may trade the resources database, you have raw material database, hundreds, or finances database. Now, this is naturally collected by the company, and the company would be entitled to dispose it of in any manner that it wants. It wants to share it, it can share it with somebody else. It may refuse to share it with somebody else. Now, in such a situation, how does the government get a right to say, oh yes, I need it for the benefit of the community at large, so I will take it away? Now, what happens to data like this? You know, companies may own IPR. IPR has a certain amount of protection under the Act, and it is also treated as asset for certain purposes. So we'll leave the discussion of IPR apart. Other than IPR, every company generates a lot of data. For example, what is going to be my business policy? How am I going to carry out this in the manufacturing area? Am I going to compete with XYZ? Or what kind of personal policy am I going to adopt? These are matters where the company has the right to evolve its own policies, evolve its own documents which will contain these policies. That contains a innumerable amount of data sets. Now, is this all to be made available to the government at the whisk of a wand? I have not understood what is it that is being suggested here. Then it is said, oh, all personal data upon anonymization will become impersonal data, or let's say non-personal data. Is that true? Technology today has not given an answer to this question. And I remember reading Conan Doyle's book, Sherlock Holmes, telling Dr. Watson and saying, whatever a man invents as a code can always be uninvented by another man. All that requires a little more careful thinking. So if you today say it is anonymous because of technical reasons ABC, tomorrow I can find out some technical reason how it can be de-anonymized. If it can be, look at the tremendous risk you are running. You are jumping from the fire, from the frying pan to the fire itself. Now, in order to protect somebody's personal right, you say anonymize it. If somebody de-anonymizes it, then you have gone into the realm of fundamental rights, and then you get into the difficulty of constitutionality of the legislation itself.
Thank you, sir.
Sorry. Then the roles of the data principal, data fiduciary are
completed, sir.
Sorry? You want me to close? Very well.
Yeah, no, in about a couple of minutes.
Yeah, sure. That's right. I was about to wind up. The roles of the data principal, data fiduciary, data protection authority, these are not very clearly laid out. So it is not possible to know what right or what obligation is there on each one of them. Then finally, interestingly, how does one deal with non-personal data when it comes to a question of transfer it across the border? The European Commission, Article 29, I believe, had a very smart way of looking at it. They say it's always freely transferable, except that if any of the particular member state makes a legislation which is going to block it, then it must come back to the Commission and obtain the Commission's approval. Now, fortunately for us, we don't have that kind of a difficulty because all states, it will be a federal law, it will go anywhere in the country. But when it goes abroad, how do you treat it? Are you going to treat it as somebody's personal property or the government of India's property? And what happens when similarly the converse takes place? These are questions that do not seem to have been addressed at all. So somebody has to really sit and do some hard thinking on this. Now, well, the law will have to focus basically on the citizens' rights and see how from there you can develop the right. The way it has been recommended, it would appear that the government should have blank check, and wherever it wants, it can make a declaration and say it is necessary for the community's benefit and take away whatever is even in the hands of a private individual, a private company. Now, on the manner of consent being taken, again, there is lack of clarity. I can't make out how and what methodology is to be used. It says consent should be given. Does it mean that I'm being forced to give consent? Then there are security issues which are very inadequately addressed. Because in the name of security, whether it is personal data or non-personal data, one cannot run away with it. One has to consider it carefully and say, the triple principle laid down by the Supreme Court, which was just now articulated, will have to be applied carefully. Although, if you treat it as property, probably you will get out of the difficulty because Clause F has been removed from Article 19.1. If it is not property in that sense, you have again a difficulty. All rights of this nature will originate again from Article 21, and you have the same problem that the Puttaswamy judgment faced. Now, these are some issues which can be considered and debated.
Thank you, sir. Thank you so much for articulating your thoughts, wisdom on the subject, which will be very useful for us to understand it better. Now, let me request Mr. Amar Patnaik, who is a member of Parliament, Rajya Sabha from Odisha, and he is also a member of the Parliamentary Committee on Personal Data Protection Bill. So, Mr. Patnaik, a couple of questions for you. One is that since you are a member of this Parliamentary Committee on Personal Data Protection, it will be very interesting to know that how you are taking into account the various interest groups while finalizing the contour and the language of this of that bill. Whereas here we are talking about non-personal data. Do you think that what kind of approach which would be needed for better regulation of non-personal data? Because I think there are a lot of ambiguities, confusion, which are there when we talk about personal and non-personal data. There are some areas, as Justice Srikrishna has also, which are overlapping between the two, and then there is sectoral overlap. So, what are your thoughts on how parliamentarians should approach it, particularly in giving a balanced importance, I would say, if not equal, but balanced importance to various interest groups. So, what do you say? And for in about 8 to 10 minutes. Thank you.
Thank you, Bipul. Thank you, the various Udai, the various authorities of the organization. I have been writing quite a bit on the personal data protection bill so far, on the functional structural aspects, and also on the multiplicity of regulators, the need for whether there is a need for super regulator, all these things. At various points of time I've written. But today we are discussing about the non-personal data. So first I would like to begin by differing completely from Justice Srikrishna, because I basically believe that, okay, I have a little bit of an economics background. So I would like to believe that if you are saying that data is the new oil, then oil as a price, it's an asset. And there is a great economic value of data. And the European Union does recognize the same. And it has given certain examples, which I thought I would start my discussion with that. When it says that the real-time notification of delayed trains can save 27 million working hours and 740 million euros in labor cost. Better allocation of resources to fight malaria could save up to 5 billion euros in healthcare costs globally. So while giving an interview some time back in Medianum, I had even before this entire thing had come up, the report had come up, I had thought that if you are, on one hand, you are saying that the citizen is not valuing its privacy message, he is not going through it even completely, he is not informed, that's probably because he doesn't value his own data. Now, if he has to value his own data, then you have to monetize it. And if you monetize an asset, it's only then that its value would be recognized. And unless you monetize it, you cannot have a data market. When we are talking about a data market, let's come to the regulation later. First, unless there is a market, there is no question of regulation. The market has to be first developed. And if the market has to be developed, then the data has to be monetized, that the information asymmetry maybe has to be minimized. So there the question of regulation would come. But the most important thing is the market has to first grow. And for that market to grow, the conditions for making a vibrant market has to be made. And that's why I believe that the entire piece of framework which has been suggested is basically oriented towards making it as a market. So I support that particular thing. Now, there are many glitches over there, which Justice Srikrishna talked about, and I agree with it. That just as like in a market, normal market of any assets, there would be several problems of principal agent problem, just like here the data principle and somebody who is executing the data principles, data and doing something about it. In economics, you call it as the agency problem. You have the information asymmetry, so you do not know what you're going to do with the data. So I think let's not kill the entire thing by saying that we should have too much of regulation. In fact, what has probably happened, and that is correctly highlighted here, is there are too many sectoral regulators now. In the United States, you don't have a super regulator. Every sector has a regulator, and I've written about it. There are too many regulators. Like, let's say the Competition Commission of India, if it is promoting competition, it is good, but it is it should discourage the abuse of competition. But the Competition Commission of India cannot probably take care of a situation where competition is not the norm, but cooperation is the norm for data sharing between, let us say, municipalities, panchayats, and gram panchayats. Let's say COVID. Now we are fighting COVID all over. There's a lot of data sharing that takes place at a very, very micro level. So I think we need to have an authority which is going which is going to actually solve this problem. And let me tell you, the MOU route is not going to be solving the problem. In section 36 or clause 36 in the PDP bill, it says that if there are problems of the sectoral regulators, an MOU will be signed. But if there is a conflict between the regulator and the DPA, or in this case the NPDA, who solves that problem? That problem is this is a big issue which is going to be there both in the PDP and the non-PDP. As regards the point that what will be the standard of anonymization, and it can actually oscillate between personal and non-personal. There is a view that because a portion of the non-PDP bill is having non-personal section 91 being the most significant, people feel that if you are oscillating and suddenly it becomes personal data protection, then it will automatically come under the bill, so it's a good thing. Some people feel that it should not actually find mention in the PDP bill. It should have been a separate authority, just like it has been suggested. So we have to find out somewhere in between. I'm not really sure how they're going to do it. But the point relating to raw data being available nationally for everybody to work on, that should be there. I think that is important. The moment you add value to data in a graded manner, they have talked about, let's say whatever you are doing, then the value as the data has to be valued. Its value should go up. Otherwise, people will not collect data. They'll not value the data, and that data will not be even collected properly. You see, the point is, unless data is there, why haven't we have been talking about artificial intelligence and the use of artificial intelligence for so long, but why couldn't you actually use it significantly? It's simply because of the fact that data was not being captured properly. Now, if we don't really value data, it will never be captured also in the particular manner. So non-personal data, I feel, I'll just say that the existing open government data initiatives, a lot of data should come out into the open, which will be useful for research, which will be useful for innovation, which will not bring, build cost to the MSME sector, which will have carve-outs for them. But overall, I am a great votary of having a data market in which the data is valued. And if some organization, of course, Dr. Srikrishna talked about cartelization, then that is where the regulation comes. That is why a regulator is required to be there. When market failures, there is a possibility of market failure. But if there is no market at all, the question of failure would not arise. So I would end by saying that there are problems in this governance framework. And that's only recommendations. Some of the recommendations would be debated. A law, of course, would have to come. It has to satisfy the principles of the Muttaswamy judgment in case it is treated as personal data, that is personal data. But the overall concept given in the framework, I am in agreement with that. And I think there's the system of incentive and disincentives for using or improving the raw data into some kind of valued data would itself drive the data economy, which would and drive innovation. In fact, if you give data anybody freely, I have a gut feeling that anything which is given free, this tendency is that you don't value it. There is a free, and there is also, if you have everything becomes a public good, then there is a free rider problem. So the best thing is to have a market, but to take care of market failures, have a regulation, but that regulation should not be very strict. It should be more self-regulation slowly coming in, because you unlock the value. You don't try to have too much of regulations to lock the value of the data. Thank you so much.
Thank you, Mr. Patnaik. Thank you for bringing economics into this subject. I do agree with you that we need to create a data market, not just a data-based market. And naturally, when we have so much of information asymmetry, which is bound to happen, there is going to be adverse selection, principal agent problems, and things like that. And here we are dealing with multiple agencies, not just one agency. And market failures, given the nature of this market, it is still at a very nascent stage. We can't really think that overnight we are going to see that the invisible hand of the market is going to work perfectly, unless we put a very dark pair of glasses on our eyes, like Mr. Karunanidhi. Anyway, so let me now bring Mrs. Gowree, because this is such a subject where we are debating the economics of this subject, the importance of developing a data market, and market failures are bound to happen. So how are we going to, then first is what is to be regulated and how are you going to regulate? I have a strong feeling that Competition Commissioner of India should regulate this market. Not because you are a former member of that body, but because of various other factors, including overlapping factors. And this is kind of, data is something which is sector agnostic as well. So it would be interesting to know about your views on A, how to regulate, and B, what would be the body that should regulate this market. So over to you, Mrs. Gouri, and 8 to 10 minutes again. Thank you.
Thank you, Bipul. And I thank CUTS for organizing a very interesting discussion, giving me an opportunity to hear B. Krishna and Mr. Amar Patnaik, and both were excellent. And I think Mr. Patnaik put it across very beautifully. And Mr. Krishna, when I read the preamble, sir, to your personal data protection bill, it does suggest data markets. The preamble very clearly suggests it. So you can't say that data is not an asset. It has become an asset. And this is something that I would like to talk about. Now, the first thing that I haven't understood is why there was a need for a non-personal data protection bill. It's something I haven't understood fully. And when data gets anonymized, because the personal data protection is more on the question of privacy, and whether there are things where you say you don't need, there's no personality involved in it, there's no private personality involved in it, it could be a non-personal private data. That is not very clear to me. And the reason why this is not very clear to me is that maybe we're the only country which has it. Most countries are going in for data protection in the case of privacy. I might be wrong. And also what worried me is there's an obfuscation. The whole report by Gopal Krishna, what I have read, lacks a certain amount of clarity, not only in terms of what is personal and not what is personal, but what is a data market. And this is what I would like to clarify first. A data market is different from a platform market. I've been saying this any number of times and people don't realize it. A platform market is a platform with markets on either side. And the platform market, because of the algorithms it uses, does collect a lot of private data. But what has happened is that these algorithms have gone out of human control and have started controlling data, which was unexpected. And therefore, platform markets do grow big. There are economics of it, there are reasons for it, but there are also other platforms which are coming up. So the issue is very separate. Algorithms have created their own abuses, which has nothing to do with the platform market. I'll take that up later. And unless one understands that the platform market is different and the data market is different, this Gopal Krishna's report makes this basic confusion, which everyone makes. And as far as I'm concerned, from the Competition Commission, I've been arguing, I've been writing that one must understand we have what is the standard product market, which is a buyer and a seller. You have a platform market, which is only a platform in between. It's like going to a mall on a digital platform. And then you have a data market, which is a data aggregator. Please remember, a data aggregator becomes just like any other market, but it buys and sells data. And some of the comments that you made, Mr. Patnaik, relates to the question of the value of data. How is the value to be provided? What is the price that is involved in it? Should we leave the market to decide the price? And perhaps we have to. Now, having stated that there has to be this kind of clarity, which why it is not coming is a little worrying for me, and that too from someone who's worked in the private sector, should understand the concept of markets and buying and selling. Now, what is interesting is even I could sell some data to which there should be a price. And I could also buy data. So the data aggregator becomes very different. And if you look at it, the platform markets collect a lot of data, but they collect what is known as personal private data. And because of the algorithms, they get into, they scroll all over, get all sorts of data, and then come up with things where the platform had no idea about. But only 50% of that data is used. Will they use that data to create a market? Will Geo and Facebook use that data? No, for two reasons. One is the data market is not a platform. If it wants to create a separate market, then it has to be a separate organization. And second thing that is also very important to remember is that the antitrust abuses which the EU has brought up, it suits the EU consumer, it doesn't suit the Indian consumer, is that they will not have data sharing, they will not allow for data portability, or, they should allow for data sharing, they should allow for data portability, and there should be a lot of platform neutrality. You're taking away the very incentives which cause the platform to grow. You're taking away that thing which allows people to strategize, which means the way one looks at data becomes very important. The way it is valued becomes very important. And that's where I agree with you, Mr. Patnaik. There's a lot of area which has to be covered. Now, having stated this, and one is looking at monetizing data, let us be very clear. Data is quasi-public. It's not a public good. It's quasi-public. It's non-rival, but it's not non-exclusive. In the sense, the moment you decide who can use it, who has access to it, then it becomes exclusive. You're paying a price for it. So it's a kind of a quasi-public data, unlike a pure public data. So it cannot be called an essential facility. Maybe some things that the government wants to can come into talking about it of essential facility, or they feel they're bothered about security concerns. There are ways of handling it. So what is one looking at it? How do you price it? How do you bring about just pure regulation to make sure who are the people of data? What is the time period that you will allow for data? And you must also give protection in terms of security. I know one of your articles recently in Media Nama, where you have talked in terms of security, security and surveillance problem. But surveillance problem could be also with the government. If the government takes away your data is equally worrying for me. You see, it's not something that this government is very honest and true as compared to the previous one. It's still my data, and I don't like my privacy intrusion. This is exactly what we asked Nandan when he got into the Aadhaar card. And that you could break into it, yes. Technology allows for it. You can break into it. So you have different kinds of data. Your Preetham from IIT who talks about commons data. So the data thing has to be really broken up, and we haven't yet worked it out in a good way. And I'm glad you have brought up the issues of principal agency data problem in terms of looking at asymmetry of information. But a data market is a new one. You see, Infosys is one, and so does Microsoft and all. But I'm thinking more in terms of people who create their own data markets. And as I said, the platform will not be the thing that will get into data markets. I'll explain it to you why. Now, when we are looking at the question of data markets, the point that is very important is that it has emerged as a very important asset. It is something what we call is not invented here. It is a data which others can use. It is a data which can be sold and save a lot of companies from spending time and energy on collecting data, or to be able to get the data across. So third parties can use the data. They can try and use this valuable data. So why not rent it out? I mean, there's nothing wrong in renting it out. Earn some money from it. After all, it's information that is valuable. And what is also important, if it is the government which has this data, you know, for example, the best data market, although it doesn't call itself a data market, is the Center for Monitoring Indian Economy. They used the National Annual Survey of Industries, and they took it from the public sector data of looking at balance sheets. There might be a lot of problems, but as an economist, as a researcher, I've used a lot of data. And once you anonymize it, personal data does become non-personal. So I don't agree that you needed another one apart from the Justice Srikrishna Committee report. But I have to say, Mr. Justice, sir, that I think there is a changing attitude towards an asset. And data is an asset. It's not something that you said, right to an asset and regulating the right, because now the entire economy runs on data. Data is the one you can rent it out, you can sell it, but you have to work out means how to do it. And in terms of pricing this thing, how do you value it? And I would think the simplest thing is to think in terms of a two-part pricing scheme. One, you have a membership fee, and now another one, you have a user fee. And in this user fee, you go on the basis of metered data. You can also work out on how much it can be used. I have only used data from the Cornell University data. You know, this is university data, and perhaps they are not so bothered in terms of surveillance, but we can work it out. It's not something that's very difficult to work out in a pricing mechanism, or also to put conditions, because when you're giving a license to use it, the license will have certain conditions. It's not just pricing, but the conditions under which the license would go on. Now, all this has become very important because in terms of pandemics, and as you said, there should be cooperation between data, and it is necessary for the municipal corporation to share the data with the Delhi government and all. That's an issue I'm not getting into. That's a political economy, not a political economy issue. It's a pure politics issue. That's not something that cannot be handled in terms of a proper data market, and to also have conditions. You can always have conditions in your license that when there are extreme conditions or when there's a pandemic, some of the earlier regulations do not apply. That doesn't mean that you have to have a universal right for the government to get your data. Now, in this question that comes up is, it's a very expensive proposition building up data markets, leaving out the platform markets, which are not allowed because there's a cap on cross-holding, and also because I'm sure Jio would want its own data market, and Facebook would want its own data market. But any data to be used by a scholar, by anyone, has to be collected, anonymized, it has to be collected, it has to be put into a format which anyone can use. Whether you want to use the Excel format, or you have the Hudava format, or you know, the different formats that are used, which all of us who use data tend to get into it. But you know how much it costs for a data market? Just in terms of, I looked at the McKinsey report, and the McKinsey estimates is the average spend was over $229 million in 2019-20 for an ordinary data market. And for the financial services, it is $323 million. And when you look at the fintech companies, there's the RBI also. And I used to have a lot of arguments with Dr. Reddy on the question of what do you do with this kind of data? Why do you need the security? And there is an importance there also, because that data cannot be easily shared. But if it is shared, what are the conditions that you're going to be put? Because they're
Thank you, Dr. Gowree.
Now, I'll just finish in 5 minutes, because I have taken this opportunity to bring into what would the Competition Commission do? Do we need more data regulators? No. The second important question that you are asking, once the rules are set, it is the Competition Commission that has to come in, because what are they looking at? They're looking at markets. And when they're looking at markets, what is the most important worry if you're going to say allow data sharing and all. That's not the way the Competition Commission should go about. What you're looking at, is there any entry barriers that have been created? And if there are, leveraging is not an issue at all. It is a question of if any entry barriers are created, and it is extremely easy for the Competition Commission to take it up, but it also means that the law, as Justice Srikrishna said, has to be tweaked. The present competition law, even the new one, has only been tweaked in the product market. It hasn't been tweaked for the platform market. It hasn't been tweaked for the data market, which means the Competition Commission has to grow much bigger, and the Competition Commission has to get more number of experts that go into it. And one last thing, Bipul, algorithmic abuses now has nothing to do with platform or anything to do with data. They have come up on their own, and there's a whole issue and talk on how do you handle things on which it is AI and machine selling. It is not AI and machine learning anymore. It is robotic selling. So let's get into the new frontier and the new game. And the data market means we're in a new ball game altogether. And I hope all of you are very passionate about it, because I'm always passionate about anything new. And I think this is what I owed to Kutz when I agreed to Udai to speak at 3:30 in the afternoon, which is not a very nice time for anyone to be bright. Thank you.
Thank you, Dr. Gowree. Thank you for reminding us several things. First is that we have to go back to our basics. This issue is complex, but at the same time, unless we start from basics, and by basic I mean what is the market? I think we need to go back and read once again some of the works of Adam Smith and Alfred Marshalls of this world. And here we are talking about a market which is new to our world, a data market, not a platform market, a market for a quasi-public good, which is different from a normal good, private good, that market, and also the market for the public good. And therefore, the reasons and also the nature of market failures are going to be different. And that is the basic which we need to understand. And here, if I'm not wrong, we are, since you have so clearly, and I'm glad that you have done it, distinguished between the platform economy and the data economy. Data economy, in that case, which is derived from the platform, various platforms, so as to say, it's a derived market. And from there, as the market develops, we can do a number of other derivations. And that's how it is going to be developed. So here, of course, we need to think more. I have a feeling that the more you supply, the more and more demand is going to be generated in this market. So you have to go back to that basic as well. With that, so let me now request Mr. Pandey to speak, Ritesh Pandey, who is again a member of Parliament and is a Lok Sabha member, and also a member of the Joint Parliamentary Committee on Personal Data Protection Bill. Now, I have of course, we are going to hear your views on this subject, but I have a question. And after hearing all these three experts on this subject, is it really, I mean, this is for Mr. Patnaik as well, is it really necessary to have this distinction between personal and non-personal data? Why can't we have just a data protection bill without abusing that word protection, rather facilitating the market development which we are talking about? So over to Mr. Pandey in about 8 to 10 minutes. Thank you.
Thank you very much for inviting me to be part of this panel discussion. It is my honor to be sharing, to be being on this panel with such esteemed people. And I thanking Kutz for inviting me to be here. To answer your question, the way I see it, there is a fundamental tension between the aim of the NPD report and the intent of the PDP bill when it comes to protection of data principles. So if you look at the very definition of personal data in the bill, it includes the data of a person who is directly or indirectly identifiable, and also includes an inference drawn by such data. So my question is, where does the inferred data end and where does non-personal data begin? There's a need to be much more clear on this and on this question. The report also acknowledges the relative ease with which anonymized data can be used or re-identify a data principle, and that sort of it can cause a harm in this case and will be addressed by the Personal Data Protection Bill. However, there may be other tangible harms to communities when it comes to sharing non-personal data of humans. So I would like to illustrate this point with a few examples. Let's say if an e-commerce company wants to look at the sale of contraceptives among women, and they find high density of women consumers in a particular college campus in the city, let's say North Campus, then if the data is in public domain, it puts women of that campus collectively at risk of potential harms from religious vigilante groups. So keep in mind that under the present framework, there may be collective harm to a community in this case, even though the data of an individual's sex life has been defined as sensitive personal data in the PDP bill. However, even in sharing of non-human objective data like air pollution data that has potential to inflict tangible harm to specific communities. Because if you're able to identify the air pollution is higher in particular areas of Delhi, say the border areas, then any restrictive policy in those areas end up in inflicting harm on the lives of people residing in those border areas. So, for example, even if you look at sort of private providers, they wouldn't go provide schools there, or so on and so forth. That can sort of affect these people there. So the question remains: who is protecting the data principles in these cases? The NPD framework, if enacted in its present form, opens up a Pandora's box of harm to data principles that are not addressed by either its framework or the Personal Data Protection Bill. So this issue is also compounded by ambiguities and overlaps in the role of data custodians and data trustees. Take the case of Arogya Setu app for a period of time that it was mandatory for employers to ensure that their employees have downloaded the app. So for Arogya Setu app data, who is the data custodian? Who is the data trustee? Is it the employer, or is it the ministry? Is it NIC? Is it Niti Aayog? So similarly for children, if you look at their education data, who is the data trustee? The Education Ministry or the Ministry of Women and Child Development? So without clearly establishing roles, who is responsible for addressing and advocating the grievances of data principles? So another issue in the report's flawed understanding of what community is. The report treats community as a monolithic entity. So it is homogeneously and rigidly defined, and its definition completely ignores the intersectionality of identities. Let us take the case of non-personal data of Dalit women. To which community does this data belong? Does it belong to the Dalit community or to women? So in a country as diverse as India, intersectionality must be at the forefront in the minds of policymakers, especially while drafting policies that aim to be at pass with the NPD framework. Now, to move further, I believe there is already a well-established need for a robust data privacy framework, whereas there's not yet a well-established and demonstrated need for a non-personal data regulatory framework that is as all-encompassing as the NPD report. Although India is not a technology superpower in comparison to China and the US, we are definitely an innovation hub for technology with a strong tech labor force. So just to give you some facts, which I'm sure all of you are aware about, out of the 394 unicorns in 2019, India ranked the third highest individual share of unicorns with 26 unicorns, followed by the UK with 15 and South Korea with 11. And we are amongst the largest exporters of IT services, according to NASSCOM. And the IT sector was set to grow by 7.7%, and it was set to add 2 lakh jobs in the present fiscal year, up from 1.85 lakhs jobs last year. So these are just some indicators of the fact that the kind of business environment we have built has worked to foster industrial excellence, and it has helped growth and innovation in the IT sector. So in such a situation, it becomes extremely important to be prudent and restrained when creating an overarching and wide-ranging regulatory intervention, as the NPD report seeks to do. I do find it a compelling argument that when innovation is at stake in particular sectors, the downside of intervening in the market when you should not far outweighs the downside of not intervening when you should do so. This is because regulations that are broad-brushed and lack nuance can have detrimental effects, especially on a sector that is so existentially reliant on the freedom of innovation in order to grow and stay relevant. So while I agree that the aim of the reports are noble, I think it would benefit from the nuance offered by both CCI as well as Indian tech entrepreneurs who have found success in present business environment. So, because we must understand that the worries we have about competition shouldn't be limited to a few foreign companies. We should also be wary of domestic companies that have outsized dominance over smaller Indian companies. And the NPD framework, as it stands today, will directly benefit the companies, both domestic and foreign, who have the financial clout to purchase the most amount of competitive data. So for instance, let's say if you take Spotify, and Spotify, obviously we all know they have the financial capability to purchase data such as playlist information, top genres of regions, listener demography, all of its competitors such as Savan and Ghana. From these competitors, they could easily purchase all of this based on the might, on their financial might. But then you have to reverse it and look at it whether Savan and Ghana do the same from Spotify, given their balance sheets and given their financial power. Similarly, Jio has the ability to purchase data of all its competitors in any of the fields it chooses to enter. But can its less wealthy competitors do the same? So I believe that the policy that intervenes in the market should always follow the principle of equity by design to ensure that it isn't directly or indirectly contributing to a power imbalance in the market. Equity by design broadly features the principles that the policy is clearly articulated with clear goals and a vision without the presence of ambiguities, which a lot of the speakers previously have pointed out. And it should, should be formulated in keeping in mind the complex power of asymmetries that exist in the market. It also takes into account achieving a level playing field, and in fact cannot mean treating all players exactly the same way when formulating a policy. So again, going back to the example I gave you about people with larger financial might. Finally, equitable policymaking also requires policymakers to continually question their implicit biases and long-held assumptions. As it stands today, the NPD framework is not an equitable framework. It will not be able to mitigate any existing power imbalances. And if implemented, it may even worsen power imbalances in the market by stifling competition and hurting the end user, which are consequences directly at odds with the report's forward-looking intentions. So, in order to sort of answer your question now, after saying all of these things, to be more direct, I feel that, the personal data protection bill that is in consultation, that is being debated right now within the committee, I feel that it can address a lot of the issues that have that have been put forward in this report of the NPD, and we don't really need another set of legislation to come in and further be a burden on an already thriving market that is existing. So although the need is there to regulate this, but at the same point, we need to make sure that we don't overburden it with regulation, especially when there is a fairly robust bill that is being discussed. Thank you very much for allowing me to share my views on this. Thank you.
Thank you, Mr. Pandey. I mean, before I go to the next speaker, Geeta, Gowree Gokhale from Nishith Desai Associates, I would like to highlight a couple of points. One, here we are talking about a market, a new market which is developing. And normally we go for regulations or regulatory reforms when we see that there is either market failures or government failures. Now, how do we determine then that in this case, what could be the possible factors between, let's say, market failures? And here we are talking about, we are dealing with a quasi-public good. So government's role is also going to come in. So this will be a combination of various things. And without any offense to anybody, given the fact that we may be fairly good, I mean, not very good, but fairly good in coming out with our laws, but when it comes to implementation, we are not that good. I mean, it's a very complex issue, and implementation has to happen on the ground. So that's one point. So my larger point is that should we not first allow this market to develop and then see the possible sources of market failures and plug them one by one or simultaneously as the situation requires. My second point is, here we are talking about non-personal data. We also have this personal data. There's a bill before the parliament. Do we have a policy to deal with data, whether the data being generated within the country or we are getting from outside the country? My point is very simple. Should we first not have a national data policy and then to frame our acts dealing with those data? So with these two questions, I mean, when we talk about national data policy, not data protection policy, national data policy, a number of other issues are going to come up, which are related to data or use of data. An analogy is the difference between competition policy and competition law. This debate is very much there, whether we should first have competition policy, then have competition law, or should it be the other way around. Personally, I think that there should be policy first and then law, because policy is much more over-encompassing. For example, in case of data, IPR issues, intellectual property rights, that's going to be very, very intrinsically related with the generation as well as the use of data. So how are we going to deal with that? Should we deal with such things through some provisions in the law, or should we have policies which are fine? So with this, let me now request Gowree, your thoughts again in about 8 to 10 minutes, so that we should be on time. Over to you.
Thank you. Are you able to hear me well, first of all?
Yeah, you're
Okay,
clear.
great. So thank you for this opportunity. I always think, in terms of a student of law, all of us are learning on a daily basis on all these new concepts, and these concepts are quite overwhelming. So before I jump straight into the current issues, I just want to sort of take a step back and see what we are really trying to achieve after this entire exercise, because I always look at anything new to start with why, what, and then how. Because if you start how first without understanding the why, this jumble gets created. And when I see this report, unfortunately I've read it at least 3 to 4 times. I've attempted to read through and through, trying to make handwritten notes to figure out what is really trying to do. Somewhere the why is getting lost in this entire report. That is the first comment. The second thing is, we are, I mean, in India, I see always, not one India, but 4 Indias, sort of, working together. And then you have this entire, humanity and the soft power, and then you have technology built. And I always visualize it that, somewhere the technology on the top is running very, very fast without trying to understand the basic humanity related issues. And then when we look at, internationally what is happening, data, oil, and all of that. But, in the Indian context, are we trying to do too many things on the basis of data without solving the real issues that are on the ground, right? I mean, that is the way I'm trying to understand it. And then where is the intersection? And that one intersection I do find in the report, that we are trying to solve some problem. And the problems can be twofold, right? When I say why, why are we doing this? So that the problems could be twofold, which are very, on the ground issues, like water conservation, can the drones data help us on that, etc., right? That some of the examples. So very, very humanity based basic problems which are still to be resolved in India. And then you have some artificial problems in my mind. You think too much, this is happening, that is happening, there is too much data getting collected, this harm is being caused, etc. Some of these are artificially created problems in our mind because we think too much, and then try to solve that without really focusing on the ground level issues. That is the way somehow I see this entire report coming out, when I sort of dispassionately look at it. So when you have so much noise, around the data, what is the focus of this entire exercise? Again, coming to why. So I see 3-4 points that are being made here. One is the security related issues to be resolved, or public good issues to be resolved, which are very, very important. And the third one is more on the competition, access to data and all of that. Now, when we have look at all this, I completely agree with what the earlier participants have said, is that there has to be, in my mind, a policy or a vision statement. Because without that vision statement, again, we are sort of going in all directions. That vision statements binds everybody together to think in one direction. Otherwise, you have cross-functional discussions happening without understanding why we are discussing all this. The second point, in terms of coming to the specific, articulation of, the concepts such as ownership and this and that, I come back to the same basic principles in terms of what are we trying to achieve out of this is the access. If I really see, with some focus to what is it are we trying to achieve is, access for solving certain problem, access for, some competition issues, etc. So if access is the point, then whether ownership issue needs to be resolved or not, because ownership is a complex issue as Justice Srikrishna said that, and even, whether that concept of ownership needs to be resolved, because, that IPR and we have seen in the copyright context, databases have IPR. Sometimes the courts have said that if it is basic information, there is no real IP, because, that can be separately collected, etc., etc. So do we need to solve the IP problem for the purpose of achieving why of this report or not? If not, let us only focus on access, if that is what the real crux of the matter is. Now, with that, I want to make a few comments, and slightly, slightly probably not in line with what has been discussed up till now. But when we are constantly talking about data, we are keeping the individual at the center, which is definitely should be the case when it comes to non-personal data derived from the personal data. But at the same time, there are businesses who are collecting that data for rendering certain services to the individuals. So on the other hand, it does become business data as well. So a balancing act, always in my mind is something which will be required to see whether are we being fair to both the parties, and have a symbiotic arrangement rather than saying one against the other. So that I'm just talking still on the concept. The next point I want to make is sometimes, when we are talking about complex issues, whether we need to go back to the traditional concepts or not, or are we evolving some new concepts? And if some new concepts, some new jurisprudence is likely to be evolved, then the discussion probably needs to be at a law commission level, etc., where certain jurisprudential concepts need to be discussed, and whether it is only can we completely ignore that kind of level of discussion when we are talking about these complex issues. Now coming to the specific questions, right? And when we talk about, I have some quick comments on say community data and anonymization that was being discussed. And anonymized data in my hands, if I sell it to a third party, may no longer remain anonymized because of the data enrichment, right? So anonymization is a very complex issue, and therefore I agree that not all data, when in my hand, which is anonymized, remains anonymized always, and therefore you can't assume that that becomes a non-personal data. The second issue on the community front, I want to also make the way the report discusses community, it being a static entity. It is not, because you will have say a geographical information, right, about certain individuals. Those individuals will keep shifting. So which community are we really talking about? If it's a moving entity, who is supposed to decide the rights of the community that existed before, say 10 days back, and today that community has changed, right? So that is a very complex issue, and I don't somehow agree that that is the right way to take forward that discussion, to take forward on the community data or something like that. What focus has to be, which I agree with the earlier panelists, is the harm. That how can we prevent the harm irrespective of the definition of community? Just let's focus on prevention of the harm by utilization of data in any context. I think if that is the focus, it is easier to solve than to solve a community definitional problem. Now coming to the entire ecosystem on data sharing or data access. On that, I have certain, some different perspective I want to share, and probably, would love if there is interaction available later on, is that what is the motivation of sharing the data? Is the motivation only that the law mandates me to share the data? Should that be the motivation? Or is there a motivation that even the biggest of the companies are motivated for a certain common purpose to come together to solve a problem relating to humanity, as I said, right? Suppose you have issues relating to unemployment, issues relating to water, access to water, issues relating to, access to clean air, or, some of those issues, right? Issues relating to health. If those issues have to be resolved, I'm sure, there can be a motivation which is higher than just the legal compulsion to share that data. That is number one. For example, nowadays, lot of investors in these companies have begun to look at ESG, right, which is the environmental, social, and corporate governance. Are the companies contributing to common good or not? And by sharing this and data, whether it is raw or value added or whatever, whether for money or not, whether that sharing that data is achieving some common purpose. So can you create those motivations in the market to have that, so that is one motivation where the investors require this to happen. The second motivation could be that, you know, you create an open source. So you have so much data with the government, multiple parties coming together and sharing that data, which becomes an enriched data, and then have that an open source data set available for anybody and everybody to have access for certain purposes, right? So basically create more of a symbiotic relationship, of course, without compromising the anonymity, because this also has a danger of re-anonymization, you know, of the individual. So whether we can create a platform, I'm not talking platform in the context Dr. Gowree mentioned, but platform for data sharing and creating that symbiotic relationship. And the next point I want to make is on the point that Mr. Pandey mentioned about India coming up with the startups, and we ourselves creating the unicorns, because there is a lot of discussion in the report which says that we need to give access to the startups to have them ability to take out the entry barrier, etc. But look at the situation where Indian startups themselves have become unicorns and are going out there. Whether they will be willing to share their data with the next startup, that is the question, right? Because ultimately you are looking at more in the context of MNCs and wanting to share the data, but what about Indian startups? Are they willing to share the data? Maybe not, because they have over a period of time worked hard over to create this, and simply sharing the data with the next startup, they may not be willing to do so. I mean, when I say willing to, of course, if the law mandates is a separate point, but as an ecosystem, right? So you need to create definitely a competitive environment, but this is too early. When the Indian startups are coming up in the market, it is too early for us to interfere in the scheme of things for sharing for the purpose of economic, bringing in economic balances. I agree, for solving humanity related problems, for solving security related problems, some mechanism could be created, but it is too early for us to create a mandated data sharing for the purpose of the startup economy. You could create an ecosystem where voluntarily people are able to come in together and create that that ecosystem, as I mentioned before, in more of a symbiotic relationship. So over to you, Mr. Banerjee, Chatterjee, sorry.
Thank you, Ms. Gokhale. So we have received a number of questions. I mean, some of them are too technical in nature. So what I'll try to do is to put them into a simple language in 2 or 3 points, and then ask each of the panelists about their views on them. First, here we are dealing with a product which can be a physical product as well as in the nature of service. In some cases, it may also be a joint product in the traditional sense of Fundnumen. Here we are dealing with a market which is developing. At the same time, there are a number of complex issues. Now, many of these issues and their complexity, I think, in my view or opinion, they are perceived complexity. We really do not know whether they are really complex or not. So there is a difference between reality and perception. So what do we do in such a situation? Should we not first, therefore the questions are, should we not first come out with a policy to deal with data, whether personal or non-personal? What do you call this? Various other categories of looking at data before coming to law. Should we have a regulator or not? If yes, personally, I don't think there is a need for any regulator. Let the market develop first, and then see what kind of complexity which are arising. Then the third and final point which I would like to make is that other than these complexity on the one hand and the implementation challenges on the other. That's another very important subject which you need to keep in mind, particularly on a subject like this. Now, let me take the example of Singapore. Now, whenever this is nothing new there, I mean, it's there from the very beginning. This is in their mindset, in their approach. They think that whenever there is any issue or any problem, there must be a solution somewhere in the world. So we don't have to spend much time on that. We have to find out that and see, given the local situation, given the local capacity, given the local complexity, how can we adapt, not adopt, adapt that solution in our local situation? I don't know. I mean, I don't work on this subject. I don't know whether, and therefore I will talk about good practices, not best practices. On many occasions, the best is an enemy of the good. So what kind of good practices which are there around the world? Has somebody looked into them? Has somebody done any situational analysis about those practices vis-a-vis the situation in India in terms of market development, the nature of the product, this embedded product, embedded with services? So these are the issues which are coming to my mind. So essentially it's about a final point. Do we need, or final 2 points, do we need a regulator or not, number one, and number two, should we first have a policy before coming out with act? So I would propose to rejig the panel a little bit and would start with Mr. Patnaik first about his views, including keeping in mind the implementation challenges. So over to Mr. Patnaik.
Yeah. So can you hear me?
Yes.
Yeah. No, to your first question, in fact, that's what I elaborated upon when I spoke, that in fact, the main purpose of activity, or the main activity of the government should now be to develop this market first, and not to bring in regulation at this stage. So market development should now actually, the correct way of market development, having the actors properly, trying to reduce, make it as perfect as possible by reducing information asymmetries, getting in transparency, clear principles, or whatever has been mentioned in the framework itself. And you talked about international practice, so let's look at the European data strategy that you have of the European Union, and then it talks about how wider access to data. So I think that regulation at this point of time is probably not required. In fact, what my friend Ritesh said, that the equity issues in the market, which are currently probably existing or which might arise later, that's the time when probably we can think in terms of a regulation. So now let's let it develop. To the question of whether Competition Commission could actually be doing it, I think Competition Commission could be doing this at a sectoral level in a very limited way. I do not think it can actually address the larger issues where public benefits can come out of using raw data or anonymized metadata at various levels. And that, by the way, government itself is a repository to a huge amount of data, which used properly by using artificial intelligence can be used for the benefit of agriculture, industry, health in several ways. Now that's not happening because people do not have the open ODI, open direct access to data in many of the state governments. So I think we should, the policy, to that extent I agree, there should be a policy to make use of this data and make it available to people. Many times the ODI, the governments, many of the state governments have got this open direct access websites, but data is not updated. Data is there some 10 years ago, whatever data was there. Then there is a big question of how to resolve the conflict at the, let us say, data is not being only created at the state, central government level or at the state government level at a very big institution. Data is being collected, is being created. Let's say Narega, MGNREGS creates a huge amount of data. Some of it is also not there in the electronic form. And how do you deal with these kind of things? So implementation, in the point which you made, in India, we have several great design things, but one size fits all strategy fails simply because implementation is different in different areas. So I think when you have a point there, and I agree with this completely, that regulation should now be completely soft touch regulation. It should be very soft at this point of time. The market should develop. We should know how to handle this data, how to use this data. People should value the data. Let the value be added to the data. The people respect the data, which Madam said about, if I want to sell my data, if just like it's my building, if I want to sell my building, I will value it this much. And if I add more value by, let's say, giving some kind of a different kind of structure to it, then I'll demand more, I'll require more. So let us market discover the price. I think that is what I would say. And the personal data protection bill has this provision of non-personal data section. I think currently that should be adequate. I in fact look at this entire framework as an extension of putting into practice Section 91. Very frankly, Section 91 was, as the government would decide, it was very vague. Now this particular framework will actually will give some kind of a framework to it, so that there will be some principle, rule-based or principle-based government taking over data. The problem is governments. Since I belong to the government, I worked in the government for so many years, the evidence-based policy making doesn't exist in India. That is unfortunately the part. We only talk about it. Many of our policy decisions are done without data, whimsically. And even if the data is there, the inputs of data or the analysis of the data doesn't get into making of that policy. And when I in the CAG was evaluating all these policies, I've seen this. 28 years I've seen this. And so the point is, now let us spend a lot of time in developing a proper market. Regulation would come later. That would be my final take on it. Thank you so much, Bipul.
Thank you, Mr. Patnaik. So your point is that let's first see the development of this market, how it develops. And let us also keep in mind that this is a market which is going to develop fast, and there is going to be a lot of changes. And it's not going to take 4, 5, 10 years to change, those changes to happen. These changes are going to take place very fast. So you have to also keep that in mind. So without any intention of even trying to understand what is happening in the committee, Parliamentary Standing Committee, my question to Mr. Pandey would be that, is it the overall view which is emerging out of this committee, or do you agree with what Mr. Patnaik has said? I mean, in about 2 minutes, since we are coming to an end, almost about 15 minutes left.
Can you hear me?
Yes, please.
So sort of going back to the question and my esteemed colleague, Mr. Patnaik's reply to it. So, the fundamental reason why the committee is working on this bill is privacy. And we have to look at the bill in that light. So the market is secondary. First and foremost is the privacy of the data principle. And, in that light, the entire bill has to be seen. The market is obviously very, very important. Now, I'm not an economics person as Mr. Patnaik, but I would say that there is an existing market where there is already business around. You can still buy data either openly or also in the gray market, and it has been shown by various journalists at a time. Now, to regulate this in order to protect the individual or the principal is extremely, extremely important. I feel that the current policy, which is the current bill that is being formulated, is working on these, on the very principle of, protecting the privacy of the data principle. And I feel that is extremely important. And, without giving away too much, I feel that the entire committee is very, very focused on primarily keeping keeping in view the privacy of the data principles, and of course, how collective data of our citizens, how that can be protected in the larger scheme of things when you look at cross-border data flows, etc., etc. So,
thank you. I'm sure that there is a market. I mean, I agree with you completely. I'll give you a very small example. At the same time, I would say that it's a diffused market at the moment. I mean, and what we are going to see in the future, that this market is going to grow and in a much more, I would say, not consolidated manner, but in a much more systematic manner. For example, I'll give you an example. Whenever I enter any building, let's say in some time building or Times of India building, I have to enter my name, my address, my mobile number. I'm sure that those data are being sold. I'm absolutely 100% sure. Maybe 1 rupee per data, right? Per entry. Yeah. You don't have to do much. I mean, you just have to click it and sell it. And there's a market for that. Because every day I'm getting at least 10 phone calls from various banks, insurance company, etc., etc. And at the end of it, if I have some time, then I listen to them and then I ask for a loan for about 1,000 rupees in order to buy a bicycle. Anyway, I'll come to Dr. Gowree at the end, but before that, let me request Justice Srikrishna for your thoughts. Should we have a regulator? I mean, these, after hearing Mr. Patnaik and Mr. Pandey, and also some others, I think there is no need for any regulator at the moment, on the non-personal data at least. So what are your thoughts, Justice Srikrishna? Over to you. And in 2 minutes.
Sorry, I got disconnected, so I didn't know whom you are addressing. Well, I agree that this document, namely the report, can be food for thought. But I totally agree with you. There is no need to have a regulator for this market. The market will grow by itself. Bring in a regulator when you find the market is resulting in inequity. Either we get to socialist thinking, which is now pre-1990, when everything was controlled by the government and the regulators, or we have opened out the market for market forces. And if you open out the market for forces, then the regulator's job is to only police and make sure that somebody does not cross the red signal. That's all. Now, that is necessary only after the traffic has started. So I agree with you that let us now focus on the personal PDP, which is intended to protect the individual's rights, which is intended to protect what is now called the privacy fundamental right, and knock out that section 91 from there, which has no place there, which doesn't make any sense in that scheme of things. Deal with it in future if necessary at all. Keep these principles that have been advocated in mind and see what you can do subsequently when there is a sufficiently developed market and a need for a regulator is felt. That is my take on the whole.
Thank you, Justice Srikrishna. I mean, see, I'm very bad with these sections and all those things. Yeah, I tend to think in a most basic term, putting myself on the shoes, putting myself into a market and how we should be developed, let's say. Now, I come from a state which is overregulated or controlled. Whether I can keep a beard or not, I have to ask somebody, not just within my state, maybe from my northern neighbor, or even in some cases I have to go beyond the Caspian Sea, so as to say, to ask for such things. So let this market be developed. That's the overwhelming conclusion which we are getting. Let this market be developed, and then we see. And the point that both Mr. Pandey and Mr. Patnaik has made, the point about equity. I'm sure that there will be instances of market failures in the sense that equity is being compromised, universal social obligations, so as to say, in some respect. In that case, we need regulation, but let it first develop, and then we can think about the kind of regulation. And in the meanwhile, let us let us study whether these perceived complexities are actually the real complexities which are emerging or not. But the fundamental point, I'll go back to one fundamental point, which is that I think we need to first have a policy in place before having a law, number one, and of course, without any quote-unquote regulator, forget about super regulator, quote-unquote regulator in place. So I would request Gowree for your thoughts, final thoughts on this in about 1.5 to 2 minutes, and then I would request Dr. Gowree for your thoughts.
Gowree or Gowree?
Yes.
Okay, Bipul, I think I do tend to agree with the previous speakers and also what Justice Srikrishna said and Ritesh and Amar, Patnaik on the whole thing. Now, you see, to have a data policy before you come out with a data law, I don't understand. The policy is one of markets. And we have decided to go for market orientation. It is true that very often with certain kind of nationalist feelings, we come about with policies which are going to go against market development, or we're protectionist where it's not required. That's a different issue, but we've already worked out that now we are going for market orientation. And therefore with that, we have to allow for the market to develop, and let's see what comes out of it. And we are looking at monetizing data. And India is the country with the most diverse data. And I must tell you that the Gopal Krishna's report talks only about data and what advantages India has. It doesn't talk about so much on non-personalized data. In fact, on the aspects of privacy, it's better to stay with the Srikrishna report. Having stated this, what would I worry about? And the Competition Commission is good enough. There's no point for us to come in, when I say us, the commission to come in, unless there is a case, because there's a greater tendency, as Gowree Gokhale said, of false positives turning up. There's a much more worry that you will intervene when it's not yet developed, or you have in India, what happens is that various people who do not want to fight on the merits come to the commission only so that a case is taken up. One good example is the standard essential patents, which is a completely private good. From being a public good, standards has made it a private good. And yet there are so many cases. So let's wait till the market warms up and then we'll see what happens. We don't need another regulator. We just need some amount of rules and regulations, and the Competition Commission can take care if there's any problem.
Thank you, Dr. Gowree. And with that, let me now request the other Gowree. Gowree Gokhale, for your remarks. I have a feeling that let's take this analogy from our great batsman Sunil Gavaskar. He used to say that give the first 1 hour to the bowlers and then the rest of the day can be yours, which is actually true, and he has proved that again and again and again. So over to you, Gowree, and 1.5 to 2 minutes, your final thoughts before I request my colleague Amal Kulkarni for closing remarks, which is about summarizing the key points, which is next to impossible in my opinion. And therefore, I'll give that to Amar.
Sure. So one couple of quick thoughts. I completely agree that this is not the time of intervention nor for the regulator. Let the markets take, sort of take its own course. But if it is felt that for a public good, something needs to be done in the interregnum, I think only on that limited point, I believe there could be some vision statement or a policy that can come out, not so much on the economic part of it, but only the public good element that has been brought into the report. Only on that limited ground, we could have a policy, a vision statement, and then some amount of intervention if it is felt that it is required. And more of an ecosystem for coming together and sharing for public good. And second, the most important point is a technical point, which I think Mr. Patnaik briefly mentioned, of the complete chaos in terms of the manner in which currently data is available today. Today, if I have to assess the COVID related situation, if at all, the manner in which the entire medical data will be saved will be completely different even within the same hospital. So the standardization, somebody like BIS or somebody, whether they can start looking at standardization of data sets, which in the long term will help us, to basically unravel the entire mystery of the data. So probably something on those lines also could be considered.
Thank you. So I take this point, let the market take its own course. And that reminds me the another point which we often hear, let the law takes its own course. I mean, you can interpret anything and everything under that adage. The only thing which I would like to add is that then in that case, law doesn't become like the river Brahmaputra or Kosi, I mean, which changes its course every year. So with that, but the final point is that we need to go deeper into this. Let there not be regulations at this stage. Let us first understand the market, its development, and then see how complexities are arising. What are the possible sources of market failures from equity point of view, in particularly, and then only then we can think about possible regulations. In the meanwhile, we should also look deeper or go deeper into the quote-unquote good practices from various parts of the world, how they are dealing with these subjects. So with this, let me now request my colleague Amal Kunkani for the most difficult job, which is the summarizing of key points. And since it is most difficult, let him do it. Let me not do it. Over to you, Amal.
Thank you, Bipul sir. I think you have done my job easier. Having said that, I'd like to make some closing remarks. On behalf of Cuts International, I would like to thank all the speakers for an engaging and enlightening conversation. I would also like to thank the participants for putting forth some fantastic questions, and we apologize if we were not able to take some of the questions due to time constraints. I would like to summarize some of the key takeaways from the discussion. First and foremost, obviously, is let the market be developed, let it develop itself. Conditions for vibrant data market needs to be created. To leverage the potential of data, it has to be valued, and an ecosystem for data sharing should be created, should be the first job of a policy or a law, which whatever needs to be developed. Secondly, there is a fine line of difference between data markets and platform markets, which needs to be clearly understood. There is a need to differentiate between data aggregators and platforms. The Competition Commission of India needs to build capacity and expertise to review entry barriers in data markets. However, the timing of intervention is the key. Third, when the market has sufficiently developed, the NPD regulation should aim to achieve equity by design. It should have clear goals and vision without ambiguities, and it should aim to achieve level playing field. It must aim to correct power imbalance, and focus needs to be to prevent harm by utilization or misutilization of data. Fourth, all laws need to be citizen-centric, and non-personal data law need not be an exception. Regulation should make a journey from citizen rights to other objectives and not the other way around. Fifth, roles and responsibilities of different stakeholders, including data fiduciaries, data trustees, data custodians, need clarity, and accountability needs to be fixed to empower citizens and ensure grievance redress, particularly taking into account intersectional identities of data principles. And finally, we understand that non-personal data is a new subject with substantial ambiguities, and the committee has done a phenomenal job to initiate meaningful conversations on this issue. As has been stated time and again during this discussion, it is now up to all of us and all the stakeholders to work together to ensure India gets an optimal and enabling ecosystem for non-personal data. On behalf of Cuts, I can promise that we will launch an in-depth evidence-based study to unravel some of the mysteries surrounding non-personal data, and would urge your cooperation in this regard in coming months. With this, thank you all once again, and we can officially conclude the webinar. Thank you very much.
Thank you, everybody. Thank
Thanks.
you.